Hello everybody, you have tuned in to Erekose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hey, how you doing, everybody? Look, I didn't really want to go live tonight. You know, it's just I've been gone the last 2 nights in a row, and I love everybody. I love y'all, obviously, but going live and interacting with a live chat really just is a lot of energy. I'm just kind of tired, but I did have a serious passion tonight to just talk about AEDPA. So that's what I did, and that's what we're going to see now. Travis and I are going to be discussing AEDPA again. There'll be a link below for you guys to see the previous time when we discussed AEDPA, if you'd like to go check that out as well. And so, you know, that's what we're going to be doing. Also wanted to say, if there's anybody out there who is good with PowerPoint or whatever, would be willing to help, Travis and I would be interested in possibly having you help us out. We're looking to maybe hopefully take a little bit of the burden off of Julie, who's been doing, you know, the slideshows, and she's been doing an absolutely spectacular job. But we're looking to maybe try to take some of the burden off her. So if there's anybody out there that would be interested in helping us out with a PowerPoint kind of slideshow, let us know. We'd be really appreciative. And you know, today we're going to talk about AEDPA, and when we talk about AEDPA, you know, we're talking about Mr. Dassey, right? So let's get to it. Hello everybody, how are you doing today? We are here today to talk a little bit more about AEDPA, or AEDPA as many call it. That is basically the piece of legislation that was passed here in the United States, and it essentially gutted the habeas writ. It robbed us of our habeas rights, and what that essentially means is, you know, you may be wondering, what it comes down to is when they passed that piece of legislation, for some reason the Supreme Court looked at it and thought, okay, this means the habeas writ is worthless now and gone, basically. I mean, technically they say there's ways to get through AEDPA, but I really don't think there is. And I can say a couple things throughout the course of this video to prove why I think that way. But you are supposed to be able to overcome AEDPA in a couple different ways, and I just don't think it's possible. The problem here is that this piece of legislation got put through Senate, Congress, whatever, and it was all because of fear. I mean, I gotta put a super big emphasis on this, man. The things that we allow ourselves to do out of fear is unreal. Okay? So how did AEDPA come to be? Right? Well, it happened after the Oklahoma City bombing. And everybody wanted Timothy McVeigh dead. They wanted that guy dead. They didn't want him to be able to, they didn't want to mess around in court. They just wanted the guy dead.
Tim McVeigh.
Yeah, or sorry, Tim McVeigh. Sorry, Tim McVeigh. Wrong name, sorry. But Tim McVeigh. Anyways, Oklahoma City bombing, they wanted the guy dead, hands down. Now, do I understand why they feel that way? Absolutely. I mean, the guy performed a horrific act and killed and injured many, many people, and it's just, you know, horrible. But do we allow our fear and anger to rule us to such an extent that we go and we pass something like AEDPA, which doesn't really make us any safer from terrorists, folks? It doesn't do a thing to make us any safer from terrorists. All it does is allows us to kill them quicker. But in the process, we screwed ourselves. We robbed ourselves of the ability to have the federal courts call BS on our own state courts if they get it wrong. Basically, it has prevented the federal courts from being able to be a check on the state courts. So the state courts now feel like they can get away with murder. Those of you wondering why Wisconsin did what it did with Brendan, it did because it could go into court and it could go AEDPA. Mic drop. I'm out of here. That's why. It's that easy for them. They just walk in and say AEDPA, done deal. We're done. That's it. That's what it's become. Do you want to be in Brendan's position in this current state of affairs? And not have your habeas rights that have been taken? You know, I mean, this is things that we got to think about in the future. There's going to be horrific things that happen, folks, in our country. There's going to be terrible, terrible things that happen. They're going to, on occasion, not every day, but on occasion, they are going to happen. We cannot allow our fear and our anger to rule us into doing something as stupid as passing legislation like AEDPA or AEDPA. All right. Any thoughts, Travis, now that I'm done ranting a little?
Yeah, fear, mob mentality. Every time we do this as a nation, react to something horrific, whether it be a war or 9/11, Oklahoma City bombing, there tends to be a group that appears, and under the guise of catching the bad guy,
right,
or doing the perpetrator in, they somehow manage to slip in something that takes away, all of these, many of the rights we have for criminal defendants. And search and seizure came in the 60s in the Warren Court. Earl Warren is considered the second greatest Chief Justice of the Supreme Court in the history of the court. Mm-hmm. But he got on a lot of rights that we take for granted now, like Miranda and Escobedo and Brady, and on and on and on and on. And they keep chipping away at it and creating exceptions and trying to chip those things away. And with the Oklahoma bombing, just like you said, we did a video on this back in December, and I had forgotten how much research you and I did, and we did slides and presentation. I pulled up.
I'll leave a link to that below, folks, by the way. Sorry, go ahead, Trav.
We pulled up the congressional record, and this was the last point I was going to make. So every time there is to quote the prosecutor and My Cousin Vinny, a heinous act, there, we get, some legislation like the Patriot Act after 9/11, AEDPA after Oklahoma bombing, and the title of it sounds so good, the Patriot Act. Well, who's not in favor of the Patriot Act?
Right.
Who's not in favor of the Anti-Terrorism Act? And then you start reading it, and then in my book, some heroes emerge on the Senate floor or the floor of the House. They stand up and say, wait a minute, you all are swallowing up our rights and swallowing up the rule. You're whatever cliche you want to use, you're throwing the baby out with the bathwater over this thing. And they get up there, and I quoted from the congressional record, two standout people that warned, this is what's going to, you're eliminating the writ of habeas corpus, is known as the Great Writ. It's only been suspended once uniformly in the history of the United States. President Lincoln suspended the writ during the Civil War. but they in one fell swoop with this legislation, and there were senators and representatives arguing, why are you destroying the Great Writ? This is, you're not going to catch any terrorists.
Yeah.
We're not going to let any terrorists go free with the Great Writ.
Right.
Why is this in here? I'm all for quick and swift justice for a terrorist.
Yes.
But, leave my
can we not
writ
rob
alone.
our own habeas rights in the process, please? Right?
And, talk about corruption. They just seize that opportunity, and it's like, okay, now's the time to go in there and chip away at some of these things that took 100 years. I mean, can you imagine 1962, you get charged, you're down in Panama City, and you're standing around on the street late at night, everyone's in bed long ago. Police come up to you and say, hey, what are you doing out here? Oh, nothing. I live here in a rooming house down the road, and well, this pool hall just got broken into. Empty out your pockets. Well, sure, no problem. And why do you have so much change? And then lo and behold, 2 blocks away, a pool hall got broken into, and soda pop machine was busted open. All the change was taken out, and 3 packs of cigarettes were missing. And then you're arrested, and you show up in a Florida circuit court, whatever the trial court's called there, and it's in the concept to have an attorney. Well, that's for a federal crime, Mr. Gideon, and we're sorry, but in Florida, you only get a lawyer for a felony if that felony is rape or murder. That's 1962. Wow. For the first time, we said, if you're going to try somebody with a felony in state court, you got to give them a lawyer. It's just not that long ago. And, that's Earl Warren. That's all Earl Warren. It's just, this aggression will not stand.
Right.
How fair is it to put a skilled, trained advocate up against the average layman? And, in the 40s, they were faced with that issue. And they said, well, the constitutional provision that says you have the right to an attorney only applies to a federal crime. And then Chief Justice Warren, 20 years later, said, that's the equivalent of legal BS. That is a fundamental right. And
did it border on disingenuous? I'm sorry. Anyway.
Disingenuosity. And this is a disingenuosity-free zone. But, it didn't border on it. It was a specious argument in the 40s, and he knew it was a specious argument then. It was disingenuous, and he said, no, the U.S. Constitution does apply to the states when it involves a fundamental right, and that's the incorporation doctrine. The point being that, if we're not hyper vigilant,
right,
if we don't have representatives that are hyper vigilant and can see through this on our behalf, because we're a representative democracy.
Yep.
You want representatives in there that don't swallow up our rights. And, I realize everybody's got different issues, that are important to them, whether, it be firearms or civil rights or voting rights or reproductive rights. And we all have them, but, I think we can agree that there's no fear or harm in allowing a federal court to take a look at whether a state court violated somebody's constitutional rights. What's the harm in that? Why throw up bricks?
Yeah,
Why throw up roadblocks, speed
exactly.
bumps?
Absolutely. It's to me it just doesn't it doesn't make sense. I mean, it's for me the biggest thing is it was sparked by an act of terrorism. And folks, I'm sure I don't remember when it was going through the courts myself. Like, I don't remember it at the time, or whatever. But you know, I'm sure at the time everybody felt like it was a good thing. Like, oh yeah, we're gonna be safer now. We're gonna be safer from these terrorists, and they're gonna be less able to hurt us, and or that sort of thing. So that sort of mentality. But the fact of the matter is that AEDPA does nothing to make us safer. It does nothing to make us safer. Some people might argue, oh, well, Mel, now people fear that with AEDPA. Well, everybody has to fear that now. For getting busted for any felony, you have to fear the fact that you do not have the right to have federal courts check the state and make sure the state didn't violate your constitutional rights. We no longer have that right. How does that help?
April 24th, 1996, it was passed.
There you go.
293 to 133 in the House, and in the Senate, 91 to 8, had clear bipartisan support, signed into law by President Clinton. But it's an incident, and it's Chris Watts is in the media a lot last few days, and people are calling out and asking questions. Can he be retried and given the death penalty? This is outrageous. He didn't get the death penalty. No, you can't retry him. He made a deal. Everybody's stuck with the deal.
Right.
The family didn't want him to have the death penalty. It was in Colorado. They still have the death penalty. They've executed one person in the last 20 years. I'm sorry. He's not going to get, it's a mob scene.
Mm-hmm.
The heck with rights, the heck with making a deal, the heck with what the family's wishes are, her family, the grandkids' family, the heck with what they want. They're Catholic, by the way, but they're against the death penalty. If he'd been given the death penalty, they would have been drugged through hell for 20 years. And that's even without a federal writ, a habeas corpus.
Right.
But you just get these incidents. It's like a legal lynching. That's what we did. We've converted. Deference. Remember that word deference with AEDPA? Well, they want to give deference to the state court. Well, what if the state doesn't allow minorities to vote? You're going to give deference to something like that?
Yeah.
I think deference is dim-witted.
Mm-hmm.
It doesn't meet the reality.
To having to actually think and consider things.
I mean, if you're in the minority and in the South, where they do hand out the death penalty like candy, it's not uniform. They don't fund death penalty defenses. It's probably 10 to 1 dollars expended, if not, up to 100 to 1. They want a lead pipe cinch. I know you use that term. There's a really good lawyer out in East Texas, who defends death penalty cases very successfully. And he said, it's really hard to get a not guilty in a death penalty case because they usually have a lead pipe cinch on guilt. Yeah. And the real issue is, what the punishment's going to be. But, what's scary is we're starting to hear now, last 5-10 years, about all of the information that they are able to sift through about us. And as a result of the Patriot Act and the FISA court, and we've heard these terms, but there were people complaining on the floor about the Patriot Act and took a lot of heat for it. And, you know, Feingold spoke out vehemently against AEDPA, the senator from Wisconsin.
Oh, wow.
And he, you know, he ultimately lost.
For you guys in Wisconsin, your senator was freaking rock solid.
And, you know, elections matter. I don't want to get into politics. It, you know, it doesn't matter, but I'm just going to throw it out here because I have an opportunity. It's election day, April 2nd in Wisconsin.
For the Supreme Court justice, right?
One of the things on the ballot is the state Supreme Court race. One position is open to replace the retiring Chief Justice who's diagnosed with cancer. The two people running against each other are both on the court that
is hearing Stevens' appeal.
Yeah, and they're on his panel. So one of them's going to stay and one of them's going to go up to the court. I guarantee you at some point this is going to hit the Supreme Court. And so if you live in Wisconsin and you're eligible to vote, people ask, what can I do? What can I do? Well, be informed about the case. If you live in Wisconsin, get registered to vote and turn out to vote on April 2nd. You can do more than any of us could ever hope to.
You have power many of us wish we did have.
Yeah, and then when you all are there in June, you know, I'm not sure if I can get out there yet or, you know, what I'm going to do, but you can all sign a card of congratulations. There's nothing inappropriate about that. Send it to her campaign chairman or his campaign chairman, as the case may be. But it's a woman and a
gentleman
running and a man. But educate yourself. I think the choice is clear, but I'm not going to tell anybody how to vote. If you need help finding resources on how to educate yourself, we'll be happy to get those to you. But no, about AEDPA, you know, what did I say the vote was in the Senate? 98 to 90.
It was pretty lopsided.
90. Let's get the facts here. It's in the 90s. 91 to 8. You know, there are 8 heroes there, in my opinion.
Right.
And you know that's part of politics. You know, they'll bundle the, you know, well, I'll push this anti-terrorism thing, but we're sick and tired. Remember Henry Hyde? Henry Hyde, the representative, and you know, led the push and the. It doesn't matter. He's from Illinois, but he was all on the floor saying that this bill was about the huge delay in somebody being executed. It goes on for years, he said the appeals went. 10 years. Well, if you're going to kill somebody, yeah, you know, spend the time to get it right.
Yeah, I want to make sure, maybe. Right?
How long was Avery in jail before? And folks, this was just when DNA was coming in. It probably had only been in a few cases across the country, and we didn't have as surefire of ways of determining innocence and guilt with DNA analysis back then. And they're complaining it took years, you know, to execute an innocent man. You know, I just don't understand. You know, who cares how long it takes? But you know, I guess they get afraid. Like in the case of Charles Manson, you know, he was sentenced to death, and then the way in which they used to do death penalty cases back then, they they did it all together, guilt and punishment in one phase of the trial. And the U.S. Supreme Court in 74, I think, struck down death penalty as unconstitutional, the way it was tried. And then a state went in and said, okay, we're going to do it in two phases. The first phase is guilt, innocence. And then, only then, if he's guilty, will we go to the penalty phase, and then we'll do that separately. And then the Supreme Court found that constitutional. But, you know, what happened to all the people on death row in 1974, or whatever year they struck down initially the death penalty? Their sentences were automatically commuted to life. That's what happened to Charles Manson. And so he ended up serving he was eligible for parole but never got it. But you know, they get afraid. Oh my gosh, what if the court finds the death penalty unconstitutional again? Oh, you know, oh my word. So let's rush these things through.
Right.
You just, you know, what's the hurry?
Yeah. I mean, so for those of you who wonder what AEDPA actually stands for, it stands for Anti-Terrorism and Effective Death Penalty Act. That's where AEDPA comes from, those words. So, something I want to point out. When Brendan was going through the federal court system, let me put my picture up for you folks. Okay, so when Brendan was going through the federal court system on his habeas run, okay, when he was in front of the en banc review, I found the decision from the majority judges of the en banc review very interesting because a couple reasons. There's two ways you can overcome AEDPA. One of them is if there is just an absolutely just egregious, just absolutely wrong in fact finding in a case, to where, how do they word it? To where
Clearly
no reasonable juror, or
yeah, well, the courts and the state court, in reviewing the jury, you know, clearly erroneous or clearly contrary to established constitutional principles.
There you go.
Or, you know, clearly contrary, clearly erroneous. So but go ahead.
So there's that, and then the second part of it, which is basically what Brendan was trying, I think, to get under, was that there's a violation of you know, constitutional law. So it's either really bad fact finding in the circuit court or in the state court, or there is a, you know, a serious, you know, violation of constitutional law. And like I said, Laura Nyrider words it too, where she says it has the wording of where there's no possibility that no two reasonable jurors could agree, or something like wording like that, where basically just means that where everybody has to agree, or, you know, it's like, yeah, it's like you have to have found the one person on earth that would have ruled that way, essentially, is the way it's worded. And everybody else has to disagree with that person in order for it to be overturnable, essentially. I may be overstating it a little, but they're basically
the flip before you go on was that even if a federal court, even if it's clear that the defendant didn't get a fair trial, before AEDPA, they could send it back and say, fix this. After AEDPA, even if they didn't get a fundamentally fair trial, if it didn't meet either of those two criteria, clear violation,
very high bars on those
of a constitutional right, or, you know, a clearly erroneous ruling, they would give deference to the state court's ruling.
Yep, what he said, that word, deference. right? It basically means
we're just
not gonna think about it. We're just gonna say, okay, we're gonna go along with the state, and that's it. That means it just means not to have to consider or think about it is all that really means to me.
Yeah. And, you know, and regardless of, well, yeah, it's mind-boggling. But,
Yeah.
Effective death penalty act,
Right.
and we're in a state like Wisconsin doesn't even have the death penalty.
Right.
But you see how they label these things.
Mm-hmm.
Why don't they just call it? I'm a true American if I vote for this bill, and I'm a communist if I don't.
Right. Right. Yeah, absolutely. Just like with the Patriot Act, right? Yeah.
Yeah.
So,
right. Yeah.
So to get on what I was saying with Brendan here, in the en banc review, you have Judge Hamilton, I believe, was probably the main one penning the opinion or the judgment or whatever it is, the order. He points out the control question. Huh? There you go. He points it out as, once again, as something that proves Brendan's guilt. Okay? It's ridiculous to me. It's absolutely beyond ridiculous to me. And Tracy Strunze even told me once. She said, "Oh yeah, he just says that because that was the finding of fact in the state court." I'm like, "Wait, isn't erroneous fact finding or poor finding of fact, isn't that like one of the things that can get by AEDPA?" So I started thinking about it. If Judge Hamilton and the majority judges of the en banc review cannot look at the control question and have a fundamental understanding of the English language to be able to understand English better than this AV technician who gets on YouTube, right? So how is it they don't see what I see, and they find that as fact? That Brendan failed the control question when that's absolutely wrong. He flip-flops on the control question. He shows exactly how malleable he is to the investigators, in the hands of the investigators in the control question. The control question doesn't prove a damn thing that the en banc majority or the state of Wisconsin says it does. And that's because of this willful misunderstanding or misinterpreting of the English language. Okay? When Fassbender says, "Do you disagree with me?" and Brendan says no, Brendan is effectively agreeing with Tom Fassbender that a tattoo existed that didn't exist. Do you understand? Okay? He's agreeing. He's agreeing with Tom and saying, yes, okay, that fake tattoo that never existed exists. Now, does Brendan know that tattoo didn't exist? He doesn't. That's why the control question proves how innocent Brendan is, not how guilty he is. It proves the opposite of everything the state and the en banc judges, the en banc majority judges, would have you believe. It proves exactly the opposite of those things. And if these en banc majority judges can't see that as a false fact and can't see that for what it is, how can I have any kind of faith in their ability to determine whether or not the state's fact-finding was just or not? If they can't see that, and they use it in their own decision to reinforce themselves because they feel like they need to, obviously, and they use that as reinforcement for their decision when it's absolutely wrong, how am I supposed to have any kind of faith in their ability to determine fact? How? Riddle me this, I say.
Want to point out real quick, one of your subscribers last night when you had a live briefly brought up, I can't remember who it is, and I apologize in advance for not being able to remember, but we'll be able to figure it out. Brought up that the act did this much, and then it started after the act got passed, AEDPA. I'm going to pronounce it AEDPA because Steve Drizzen calls it AEDPA.
I introduced it as both, so that's fine.
You can call it AEDPA. I was going to call it AEDPA because someone great like Steve Drizzen calls it AEDPA.
Yep.
So anyway, so the act took it to here, and then the circuit court judges, that's the appellate court level in the federal system, they took the language and then molded it to these standards you were talking about earlier. And she pointed it out. Wasn't it a combination of the act and then court interpretation? And in fact, it was. That was very astute observation. So it was a combination of the two. And there are, appellate courts that, especially the Fifth Circuit, they get a new act, and they just love, just being able to take it one step further. But these heroes on the Senate floor, my interpretation of a hero, these senators on the Senate floor and these representatives on the floor of the House stood up there and said, "You're not fooling anyone. They're going to take this language and they're going to take it to the next step, and you're going to emasculate," I'm paraphrasing, "the Great Writ."
Right.
The Great Writ. It's what stands between the government and a citizen accused. You can't go around and lock people up, throw them in jail as a material witness. We're gonna keep you in here until you're ready to talk. The Great Writ is what prevents the government from being able to do that. Right. From not complying, not having the right mental attitude that the government wants you to have. The Great Writ prevents them from rounding everybody up and throwing you into a concentration camp. The Great Writ wasn't even suspended during the Japanese internment. They relied on other grounds, so they passed a specific statute. We don't suspend that writ lightly. Yeah. And we can only be done in times of war, and the President Lincoln did it. And we can debate in many, many, many other shows about whether that was right or not, but you don't mess with that thing. Yeah. And yet they were this act of terrorism left this little doorway, and they said, "Well, we're gonna tack this on this anti-terrorism thing because nobody's for terrorism." And look what it's evolved to. A 16-year-old boy
shut down,
run through the ringer. His only hope, and everybody knew after AEDPA that everything was stacked against them. And his only hope was, a lowly federal court, and miracle of miracles. Yeah, your rights were violated. Your confession wasn't voluntary. That's all the issue was. Was this a voluntary confession?
Right. How can it be when 95% of the facts are fed to you?
Because his will wasn't broken. He didn't flop down on the floor and burst into tears and throw a fit. I'm being facetious.
I know you are.
His will wasn't broken.
But hey, I just don't see how it's a confession when 95% of it is given to you. That just goes against the whole idea of a confession because, anyway, that's my thought.
And they cited all the right cases. Well, Your Honor, no, he didn't flop down on the floor and have a nervous breakdown. They didn't break his will, but all of these other cases, Miranda, Escobedo, on and on and on. They use that language, you don't have to produce blood to break somebody's will.
The blood of the suspect is not the only hallmark of a will overborne or of a coerced confession. That's wording from the Supreme Court, folks.
DFG, baby. DFG.
Yep. Yeah, so that's absolutely true. And I'll tell you what, folks, it's scary that the Supreme Court has not looked at a case for juvenile of juvenile confession, case or coercion case, really. And I think it's 40 years, something like 40 years, or maybe it's 25 years. I don't know. I think it was back in the 70s, if I'm not mistaken. So I think it is 40. But it's been a long time since they've taken on a juvenile confession case, and they don't seem to have an interest in it. And with AEDPA there, I don't know that they're ever going to. I have heard, I don't know, maybe you can help us out here, Travis. I've heard that you don't get a lot of cases that go straight from state court and petition the Supreme Court of the United States. Is that true? I've heard that there's like a way to do that. You like have a choice to either go one way or the other, and usually if you choose one, the other option disappears while you're pursuing that option, right? Do you know what I'm talking about? You can explain it?
Young Blood was an Arizona case, went to trial, then it went to appellate court, went to the Supreme Court of Arizona, and they appealed it directly to the U.S. Supreme Court, and they accepted cert. So you have the option, you have two pathways, but it used to be before AEDPA, you really wouldn't want to do that. You'd want to, pursue federal habeas and go from there. And the reason why is that there are so many cases, petitions for cert that get submitted, thousands.
Yes.
And they take less than 80, take about 75 a year. And even if somebody has a legitimate federal issue, federal claim, they may just have to skip over it and wait. And because they do look at every death penalty petition that's filed with them.
Right.
They do look at every single one of those. There's always a judge assigned, and it rotates. But they will intercede and say, well, we're not going to accept cert, but we're going to delay this for 30 days so the state court can look at, is the mixture of drugs appropriate, something like that.
Whatever kind of fact the case, right? Yeah.
But there's it's just really tough to get a case heard by the United States Supreme Court.
But it is because people are actually exercising that option now, going straight from the state Supreme Court to the U.S. Supreme Court now, instead of going the habeas route, right? Because like Zellner says in MAM2, you're better off going on 15 or 16 successive motions or petitions in the state courts before you ever darken the door of a federal court, right? I mean, most lawyers are looking at it that way nowadays, right?
Well, they're certainly saying, well, but because it's so rare, and you put me on the spot, I can't think of that many that have had much success in federal court, but there's one that I only remember this because you and Allie have been talking about it a lot. Darley's relief for additional testing was because of a federal habeas petition, and a federal judge in Dallas ordered, and it's been on hold for years and years and years for this testing. But, you know, I think that no one's in a big rush to do anything with her. The state, certainly the defense lawyers aren't in any huge rush. They just want to get the testing, but it's no, your best shots in state court, on whether they call it a writ of habeas corpus in state court, or they'll call it a motion for post-conviction relief. And like in Wisconsin, you know, the 974.06 is the habeas. And Zellner and MAM2 was, you know, and she was saying, oh, yeah, you don't want to go to federal court. And then, you know, boom, they won. And then she's like, oh, you know, it's great. This is awesome. And then they lost. And the way they spliced it together and edited it, it was kind of like Zellner, like, see, I told you, you never want to go to federal court. Who knows how that actually was? You know, I know Kathleen Zellner was totally for them and hoping they were successful, and she was hugely critical of the en banc ruling. And but I think she just sees it from the practical standpoint that you know,
AEDPA is a roadblock, folks.
Yeah, and you know, would things have been different if they'd stuck in state court on the confession in Wisconsin? I don't think so.
Yeah.
You know,
at least going to the federal courts, they called a hell of a lot of attention.
Yeah,
right? That's one thing.
You think happened. Judge Angie was going to find that?
Yeah.
Statement, that confession, that those interrogations, coercive?
Right.
I think not.
Right. Yeah, absolutely.
So, you know, the second guessing on that, but and I don't think Kathleen Zellner was second guessing them. I think she was pointing out things from her perspective and the way she's been successful in getting cases reversed and sent back for a new trial.
Right.
And she does it forensically. Well, there's not, with a clearly coerced confession, you don't need forensics. Right. And really, the federal route on that type of an issue isn't that bad, but on a case where you have a false narrative, and then it turns out either inadvertently or intentionally the state presented a false narrative. Could be unintentionally, and then it's discovered through what I've been referring to as smoking gun DNA. Clearly could not be the defendant. And then, you know, it basically bypasses the courts. The DA gets in there, the AG gets in there and petitions for the release of the defendant based on the evidence. Of course, the court's got to grant it, but when you got the DA or AG saying, hey, this guy's actually innocent, and he should be released tomorrow, you know, that's what happens. And that's what happened with Stephen's first case. Ultimately, you know, they said the fingernail scrapings of the victim weren't enough, even though that came back.
I know. Yeah.
Somebody else.
Yep.
You know, but no, it's, you know, I don't think she was second guessing. I just think saying, you know, the types of cases she's had where you win the cases on the forensics. She also said, you know, if I can point to an alternative suspect, she was stronger than that. If I can point to the real killer, I try and do that. Right. And she said, you know, some attorneys think I'm crazy for doing that. And she said that because, if then you're having to prove two things. One, that your client is actually innocent. And then number two, that this is, the other person that did it. Why put that huge burden on yourself? And she's had some cases where she was able to do that. She had smoking gun DNA, that one piece of evidence or two pieces, these pieces of evidence not only conclusively showed that her client was innocent, simultaneously they conclusively showed who did it, and they were in CODIS, or they were able to put that together. But that issue came up in West Memphis 3 too, that they had the profile come back, and then they were trying to get DNA on one of the stepfathers, and they came up, the defense did, with some creative ways to get that. But that's a story for another day. But
I think we've kind of gone over and covered it here today quite a bit. So any final thoughts before we go?
Well, Kathleen has kept it in state court, and she's not going to just let them rule against her and then, jump over into the federal side. She's already exhibited, she filed the equivalent of a motion to stay. It was called a motion to supplement the record a year ago regarding that late serve CD disc. That delayed things about 5 months. There was a ruling in September of 2018. Then her brief was going to be due in about the 17th of December. Found out there's some new testing might be available. She didn't care. It's like, okay, I'm going to file a motion for stay and remand and try and get these bones tested. And so I can put one more brick on my wall and chip away one more brick from their wall. And people, were a little bit unsettled about that. The state said, oh, well, why don't you just dismiss your appeal and then you can test? And then, they denied it. Then, she goes, wait, what are we talking about? These bones were returned, filed another motion. Hey, look, I just learned these bones may have been returned. I can't get a straight answer out of the state. I want to stay in remand and get these bones sorted out that have been supposedly returned to this family. And people, a little bit more disgruntled, when are we going to get this thing going? And this appeal's been languishing for 18 months. Appeals don't languish. People do. Yeah. And, here we are. So she's committed to sticking it out in state court as long as she possibly can, and she's just going to go. Yeah, they want her to go away. Never forget that line. They just want me to. They just want me to go away. And you think Judge Suck at This is finally figuring out I'm going to have to deal with this.
Yeah, they're starting to realize that Kathleen's like a pit bull. And she's got lockjaw.
Those are my final thoughts. That is as bad as AEDPA was in emasculating the Great Writ. We don't have to worry about that because Kathleen has got plenty of ammo and plenty of things up her sleeve yet to go in state court. Right. Hopefully, we'll never have to face AEDPA because she can get all the relief she needs in the state courts.
Let's hope. Certainly, that's what we hope for. So, all right, folks, we're going to go ahead and wrap it up. Just remember those things that I was telling you today, folks. AEDPA, remember it. Remember what we talked about today. Remember what it is, how it came about, why it's so ridiculous. It doesn't do any of the things that you would hope it would do, considering what we gave up for it. Okay? Think about that. considering what we gave up for it, you would think we would have gotten a heck of a lot in return. But basically, it didn't make us any safer. It didn't make us any more protected from terrorists. It didn't do any of those things. All it did was screw us. Okay? We have to start paying attention, and we have to start holding our politicians accountable, folks. It's the only thing that's gonna prevent tragedies and travesties like this from happening. AEDPA was just wrong. Sorry?
Forgot to mention Kathleen's motion is due this Friday. This is the motion that the court, in granting the stay and remand regarding the bones that were probably returned to the Hallback family. She gets to not test them, but bring the motion as to how that is a violation of the Youngblood case and or the evidence preservation statute. They gave her 14 days to file her motion with the circuit court. That would make it due this Friday by my calculation thereabouts. So might be something really big to talk about on Friday.
Yep.
And we'll be ready if she does, right, Erekose?
Yep, absolutely. Hopefully we'll have Tracy Strunsey with us as well, but we'll have to see how we'll play that one by ear. So, getting back to what I was saying, though, it didn't make us any safer, folks. All it did was rob us of our habeas rights, as Travis refers to it, the Great Writ. This should have never happened. We have to be mindful in the future. We can't let our politicians do this. We can't allow our politicians to use fear and anger that we feel over, something to convince us into giving away more of our rights like we did here. We can't do it, folks. We have to be mindful. Constant vigilance. You got to pay attention. We got to watch out for stuff like this, because how are we going to get this corrected now? It would take nearly an act of God at this point, probably, to get anything done about AEDPA now. Okay? I mean, literally. Maybe if everybody at this, if everybody started acting up about it and writing their congressman, I mean everybody. I mean literally people in every state, thousands and thousands of people in every state started writing, maybe there might be some movement on it. I mean, it's going to take us getting involved, us voting in the politicians we want that are going to look at AEDPA and see it for what it is, the huge turd that it is. And so that we can hopefully get rid of it. But if we can't get rid of AEDPA and we can't get rid of these horrendous things that we did to ourselves out of fear and anger and maybe even a tiny bit of ignorance, then we got to make sure we don't let it happen in the future. We got to stop things like it from happening again and again and again. It's up to us to be the traffic cop, folks. I can tell you right now, our senators, our politicians didn't. 99.9% of them are in it for themselves. They don't care. It's up to us. We're the traffic cops. We're the referee. We're the one that has to get involved, and we do that with our votes. That's why it's by the people, for the people. That's why these words are in the United States Constitution, because they actually are true. Some people allow themselves to despair in the fact, well, I'm just one person. Well, you know what? And a lot of people who are just one person make that same stupid argument in their head and don't vote. And next thing you know, a huge portion of the population didn't vote that might have made a difference. Because, like I said, it's not just you that, if anybody who's ever said that to themselves, not just you who says that. It's not just you. There's thousands and thousands of other people who will say the same thing to themselves. And when you get thousands and thousands of people who aren't showing up and voting their conscience and taking part in the process, your one vote maybe doesn't matter. But when people think like that, it becomes more than one vote that doesn't matter. And that's the problem. So look, folks, hope we've given you guys some things to think about. Constant vigilance. Gotta watch out for things like AEDPA. These things just are not good. I'm telling you, folks, we are not any safer. We are not any better off than we were before AEDPA. other than the fact that we no longer have our habeas rights. That's the only difference. And we allowed our fear and our anger and like I said, even maybe a little bit of ignorance to allow us to accept it back in 1996. So, I'm going to leave it at that. If you haven't already, please hit subscribe, and we'll see you.
Good night. Good night, everybody.
Okay, so I'm done ranting for the night. There you go. Anyway, sorry about that. Anyways, no, I'm just kidding. No, hey, look, I'm passionate about this stuff because, I don't see any purpose to AEDPA. Literally, to me, seems like its only purpose was to rob us of our rights. I mean, literally. How many people honestly feel like we are somehow any safer from any kind of terrorist act because of AEDPA? How is AEDPA actively protecting us? I mean, I don't see how any. I don't know how the wool got pulled over the eyes on this. How so many senators voted the way they did when this so obviously doesn't do anything in terms of. All it does is make it easy to kill somebody who we catch. That's all it does. And in the process, making it just to make it easier to do. And in the process, we sacrificed our habeas rights. Anyway, so I don't want to rant anymore, so I'm just going to go ahead and say thank you. Big shout out to my moderators who are doing a great job, over here. And thank you to the Wrecking Crew. You guys are awesome. Everybody taking part and looking into the case. And now we're starting to kind of move into other cases. We're going to be obviously looking into Scott Davis. Some of you know who that's. That's a big case for me. Recently had a case handed to me by Georgina Stulenbos, who is the head of the Dutch support page on Facebook, and she is phenomenal. She translates a lot of the court documents and stuff for her fellow countrymen and everything. She does a lot of work. She's very passionate for Stephen and Brendan. She's awesome. So I'm gonna be reviewing this case a bit and looking into it, and me and the Wrecking Crew and I may go ahead and dig into that one a bit and start checking that one out. So anyways, those are some of the things coming up in the future, but obviously big thing is looking forward to Friday. Well, Thursday, Friday, maybe Monday. Travis seems pretty sure it was Friday. We could go back and do a count. But anyways, we got the motion. I'm sorry, not the. Well, it is a motion. The motion for the circuit court coming from KZ. That's going to go to the circuit court, which will obviously be seen by Judge Sukowitz. Or Judge Suck at this, as some say. Anyway, so. That's what's also coming up. So we got a fair amount of things kind of, happening and whatnot. If you, like I said before, if you haven't already, please hit subscribe, and we'll see you.